Good afternoon and welcome to yet another episode of Ask a Lawyer. So my name is Sanjeev, I represent Vakil Search, and we have with us Ms. Pooja Shri, who is an IP attorney and our lawyer for today. Good afternoon, Pooja.
Good afternoon.
How are you doing today?
Good, very good and very excited.
So Pooja, being an IP attorney, I understand you would come across quite a lot of interesting cases when it comes to trademarks or IP filings. Could you please throw in some more light in the lines of IP filings and trademarks?
Yeah, sure. So IP is like a vast subject wherein you have trademarks, you have copyright, you have patent designs and all of the other stuff. So I personally specialize in trademarks, and so we do about by we, I mean we at Vakil Search file about 600 plus trademarks every month. So that's like a huge chunk. So trademark filings are like almost maybe 650 plus every month on average. And besides that, we also do copyright and we do trademarks. And the new service that we have launched, which I would like to speak about, is about US trademark filings.
Amazing.
So yeah, so that is something that we have launched like maybe 2 or 3 months back, and we do file trademarks in the US. Apart from that, we also have something called as a trademark watch service, which I would recommend for all trademark applicants to have, because trademark filing does not only stop with the filing. So after filing, you need to very strongly protect your trademark against all the...
There are likes of oppositions.
Yes. So you need to have a close watch and to keep a close check that your trademark is not being applied by anyone else, and then you don't need to wait until their mark even reaches the opposition stage or that something of that sort. You can anytime send a legal notice as soon as you see that someone else has filed a trademark at the initial stage itself. So that is also a new service that we have launched called the Trademark Watch Service, which is pretty intense on protecting a trademark.
Amazing. That is something phenomenal that Vakil Search does. As part of our regular Ask a Lawyer service, we've been waiting for questions to pop in from our audiences. Meanwhile, Pooja, if you could explain a little more in terms of trademarks in India versus the US, that would be really great.
Yeah, sure. So trademark is like, so the trademark process on a general basis, if you see the skeleton of it, it almost same. So a trademark has to go through various stages. After filing, you have something called as the examination, you have something called as the objection, and then you have the opposition, and all of that happens. So those stages are standard for India and the US. However, maybe the difference, what I see in the US trademark that is not very strictly followed in India, is the usage concept. So in the US, if you need to file a trademark and claiming usage of a trademark, saying that I have been using this trademark maybe from so and so XYZ time, you need to provide specific proofs of that. In India, although we do file a user affidavit and the practice is prevalent, but it's not as stringently followed as in the US. Apart from that, it's the procedure is more or less the same.
Understood. So besides being an IP attorney, Pooja Shri is also one of our experts in the legal panel. So she would be here answering questions. In fact, we have a question from Mr. Baiju Basumati. So he's mentioned, my unmarried aunt has purchased an LIC policy and my father was the nominee. But the question is that both persons have expired. Now who will be the legal heir? And the sister is a purchaser. So how would we address this?
Yeah, so as per the family law, if there is any unmarried lady, the class 1 heirs would automatically be the specific lady's father or the mother. So in the event that Mr. Baju's aunt is if her father or her mother are alive, they would be the class 1 heirs. In the event father and the mother both have expired, then in that case, it would be either of their siblings. For example, if your aunt has a brother or a sister, then they would take they would automatically take the share of the LIC policy. So they would become the nominee and they would take it off. They would be the nominees for that and they would equally share it.
Great. in the due course, we've also been asked by Mr. Rohit Varma, and surprisingly, this user has come in from YouTube. He says, "Is it must the death certificate issued by the legal heir or successor only, or any other person outside the family also be a part of the legal heir certificate?"
Okay, so the death certificate and the death certificate can be applied only by the legal heirs who succeed the person who has expired. So that is in general cases. However, if there are no and if the legal heirs too have expired, or certain circumstances you may not have any legal heir, in that circumstance it depends on how the property is to be transferred. For example, if you take the example of will, who would apply for the death certificate is the executor of the will. So you have someone called as the executor of a will. So the executor, despite of the fact whether he's a family member, whether he's a legal heir or not, the executor will and can have the rights to apply for the death certificate. So to answer the question, on a general basis, the legal heirs are the only person who are entitled to apply for the death certificate. But in certain exceptional cases, wherein the legal heirs not present, a third person may also apply for a death certificate. And like as I gave you the example of a will, in the case of a will, the executor would have to apply.
A third person, is it mandatory that he has to be a part of the family or an extended family, or it could be any individual?
Yeah, so it can be any individual. As I said, the executor of a will need not always be from the same family. He can be a neighbor, or he can be a friend of the person who's wrote the will. So it can be any individual. However, he has to be of the legal majority age. So he has to be above 18 years. So those things are general. But apart from that, if legal heirs exist, then only the legal heirs can apply for a death certificate.
Right. So this is with regards to death certificates. In terms of legal heir, what which members of the family classify as legal heirs? Is it only the counterpart, or is it only the spouse of the deceased, or it could be spouse of the deceased and his children or her children, or could it be an extended family member as well?
Yeah. So when it comes to legal heirs, something called as class 1 legal heir, class 2 legal heir, class 3, and so on and so forth. So class 1 are the first category. So in case there is a person who's expired, so the immediate, so as I said, for an unmarried lady, the class 1 legal heirs would be the mother and father of the lady who's expired, as long as she's unmarried.
Right.
And if there are no class 1 heirs, for instance, if the mom and the dad also don't exist, then automatically the legal heirs would go on to the class 2 legal heirs. In the case of an unmarried lady, it would again be the brother and the sister who are born with her. So we have various classification. If class 1 do not exist, it would move on to class 2. If 2 is not in existence, it will move on to class 3 and so on.
Class 3 and so on. So
Yes.
speaking on those lines, what if...
It would be like, you can say, the nearest kin.
The nearest kin.
Yes. So it would go on like that.
Right, the closest kin in the bloodline.
Yes.
Perfect.
Yes.
Perfect. Thanks a lot, Pooja. And Mr. Achyutanandan, I'm so sorry. Beg your pardon. Mr. Achyutanandan KaminiSh. He's live on Facebook as well. Hello, Achyutanandan, if you're live again. There seemed to be a signal discrepancy. If you're live again, hello there. So he has a question for us. He says, is there any legal consequence if I'm using a famous foreign movie's name for a short film which I'm planning to make in my regional language? It could be in Tamil, or it could be in any language. And the story of the short film is completely different.
Yeah, so it's a very interesting question. And I've actually had many clients come to me and say that there are various brands that exist, maybe in the UK, US, or, some other foreign country, but they do not exist in India and they do not have any sales per se in India. In that case, maybe I can start using the brand in India. So the answer for that and the answer for Mr. Achyutanandan's question is no. So as far as his question goes, it's a foreign film, right? So despite of the fact that whether the script is on similar lines or not, or anything of that sort, as long as a foreign film has So it is a film that exists maybe in the US, and so they would have applied for a copyright for that. So copyright not only protects the script, it also protects the name of the film. Apart from that, nowadays, given the importance of trademark, people have actually started trademarking the name of films. So it's not only the copyright legal protection that exists, you also have trademarks involved. So I'm pretty sure that if it is like a foreign film, they would not only have a copyright for it, they would also have a trademark done for the name of the film. And apart from that, the second question that Mr. Acharanandan may ask is, since it's a foreign film and it may not even be released in India, or people in India may not even see the film, even then, is it a legal problem? The answer is also yes, because we have a concept called the trans-border reputation. The meaning of trans-border reputation is, even though a trademark is not filed in India, even though it is not been used in India, but given that we have the internet being flourished like this, so I can view, or I can even though if I can't watch a film, but I can see the teasers, or I can get to know that a film called XYZ is being released in the US. So the concept of trans-border reputation plays a very important role. So just because a trademark or a film is not being released in India, or it's not viewable for the Indian viewers, does not mean that we can use that name of the film and you use it for our short film. So there will be legal consequences for that.
Right. Should there be a conflict that has to be addressed in a court of law, either from the home country from where the inspiration has been acquired, or is it anywhere? Does that apply anywhere?
Yeah. So, for instance, if you use a brand that is a US brand or a UK brand, and you start using it in India, and they come aware of it, they would first send a legal notice, and it would so they can immediately file a trademark in India claiming use from the date that they have been using it. So they might not intend to use the trademark in India, but nothing stops them from using it from the day on forth. Right. So it would be the Indian authorities. For example, it would be the Indian Trademark Office, wherein they can take legal action against the infringer who's filed the trademark in India.
Right. So on account of people using it in India, and there is a conflict that arises, it can be addressed from courts in India.
Yes, it will be addressed from courts in India, because at the end of the day, the infringer is using the trademark for commercial purposes in India, and the person whose trademark is being infringed, he has all due rights to apply for a trademark in India. So
Understood.
That would be the case. Yes.
Fair enough. Right. So, hello, Mr. Shiva Dattu. Thanks for posting in this question. He says, no legal heirs having, but what do you do when you have a legally adopted person, when you don't have a legal heir? And is there any chance to enter his name in the family member certificate?
Okay, so this is pretty complicated. So as far as adoption goes, it has to be legal. In this case, I see that the adoption is not legal. So in that case, what you would have to do is, the first thing that we would have to do is, we would have to get a declaration of the adoption by a civil court. So the person who is not legally adopted has to file a declaration suit in the civil court, wherein he would be it would be like he's filing the suit against all the nearest kin in the family. Right. So if I am being adopted in a family, I am not legally adopted, then I would have to file a suit for declaration of my adoption as legal. And the opposite party in that suit would be all the nearest kin that are there in the family. And only if the court gives a favorable judgment and says that my adoption is legal, can my name be included in the family certificate. Apart from that, it is a very tricky thing to not have adoption legally. So it is also an advice to all of them who are opting for adoption, is to always make sure that your adoption is legal. because as far as the law goes, if it's not a legal adoption, then the person adopted can actually not be considered as a legal heir of that family.
Fair enough, understood. So I hope, Mr. Rajesh, your queries have been addressed too. And moving forward, we have another question from him. He says, who can be a witness in a will?
Okay. So any person who's above the age of 18 years and who's of sane mind, basically any person who can enter into a legal contract in India as per the Indian laws, can be a witness to a will. However, the beneficiary of a will, say for instance, the person who's getting the benefit from the will, cannot himself be the witness. So apart from the beneficiary, anyone else can be a witness of the will.
Perfect. All right. So we've been having a series of questions pouring in. So I'm afraid due to the constraint of time, we might have to skip on a few questions. We'll be happy to address these questions on an individual note. We'll be happy to respond back via messages or comments to your questions. Please do feel free to post your questions on comments on the following social media channels: Let's Vakil Search on Twitter, Legal Vakil Search on YouTube, and Vakil Search, facebook.com/Vakil Search. So now moving on, we do have a question from Mr. Vilvatri Srihari Varma. He says, I have seen publisher providing information about Piranhas. Can I use it? Does religious books hold copyrights? Can I use it? Does religious books hold copyrights?
Yeah. So as far as copyright is concerned, copyright exists only in the original work.
Right.
As I can understand from his question, Puranas are something that exist from, so these are there. So, but there is a concept of adaptation and translation.
Right.
So the Puranas, if I'm not wrong, would be in Sanskrit language.
Like, any of the vernacular languages.
Yes. So if you just use them as it is, for example, if a Purana is in the Sanskrit language, you don't do any deviation or add any interpretation of yourself. Like, you don't yourself add any interpretation and you just use it word to word. There is no copyright infringement case there. But there are certain publishers and books that interpret the Puranas, that translate the Puranas, that adaptation. So adaptations, translations, interpretation, there is some original work of the author that goes into it, and that automatically attracts copyright. So if a Purana is being translated or is adapted or is, or any original content of the author goes into it, or if the author explains it using his own words, then yes, copyright in that exists and you cannot use that.
Right. So is it subject to proper references and citations?
Yes. So not only proper reference and citation, sometimes you would have to personally contact the author and get his due authorization saying, so if Mr. Vilvatri is, so if he's going to use it for his commercial purpose, then he would have to get a proper NOC, like a proper authorization from the author of that book.
Right. So considering that is an epic, and epics have different schools of thought.
Yes.
So does this limit authorization from ethnic communities?
No. So when it goes to like, for example, the Mahabharata and all these books, right? So copyright protection extends for 60 years,
right,
or until the life of the author.
Right. In this instance, the interpreter who is...
Yes. So if in this instance, if someone has translated a certain book, or if someone has interpreted a certain Purana or something, the copyright for that would exist for 60 years or until the lifetime of the author, that is the interpreter or the person who's translated it. Beyond that, copyright does not subsist in that work. So he would have to maybe do a bit of homework to find out, who the author is and all of those stuff. But copyright protection exists for 60 years or until the lifetime of the author.
Absolutely. Right. Thank you. So we have Interestingly, we have a viewer from Instagram who's messaged us, who's asked this question. His name is Pandit Raju Thakur Mishra. So he says, in his CBSE school certificate, he wants to change the surnames of his father and mother, and he wants to change his surname. He would like to know the procedure.
Okay, so there are two instances which can lead to such changes. First instance is maybe the CBSE certificate has a wrong surname. So all his other ID proofs, such as the Aadhaar or any other ID proof, as well as his previous school leaving certificate and all, would have certain other surname. For example, the surname would be Mishra, but only in the CBSE certificate, maybe by mistake some other surname is included. If that is your case,
right,
then all that he has to do is he has to produce some other ID proof. That is maybe his Aadhaar card or something that has the original and the correct surname along with his previous. So maybe he would have a school leaving certificate or transfer certificate or something which has correct surname. All he needs to do is produce an ID proof with the correct name and surname, and the school leaving certificate with the correct surname, and the CBSE certificate will be changed. So
right,
that is instance number one, when there is a mistake in the surname. However, if he wants to change a surname wherein all his documents, all his ID proofs have surname, and he wants to change it entirely, then he would have to go for a name change service. So how the name change works is he would have to get his name changed, published in an official gazette. That official gazette has to be a national official gazette. Only after that can he change his surname in all the other documents. Specifically concerning CBSE certificate, the procedure is a bit more tedious because if you do the name change within a year, so for example, if your CBSE certificate is issued in 2010 and within 2011, if you do this name change process, it would be much quicker and simpler. But if the CBSE certificate is 2010 and he wants to change it now in 2019, that would you would have to get a civil court's order.
Understood.
That order would come. So first he would have to get his changed name published in the National Official Gazette. After that, he would have to approach the civil court and get an order ordering or instructing the CBSE authorities to change the certificate. So that is like a pretty tedious process. So it is advisable, if you have any mistakes or if you have any changes to be made, the change ought to be made like within a year max.
Right.
If it goes beyond that, it would be a very tedious and a long procedure.
Understood. So, owing to time constraint, I'm forced to take up one last question, which is from Prince Yadav. He says, the name has been published in Gazette as well. He's a government employee. Now he wants to change his name in his office. So he says they demand a mandate. So can you give a mandate to change the name?
Okay, so as I explained, the name change process, it ends with your name being published in the National Official Gazette. So there is no other procedure or there is no other mandate that is needed. So as soon as you have your name published in the National Official Gazette, you can use that as a reference to change your name in all the other documents. But I understand that Mr. Prince is a government employee.
Right.
So I think his mandate that he's talking about is very particular and specific to the office that he works in. So that particular government office may have some additional requirement apart from the official gazette notification. So I would request Mr. Prince Yadav to get in touch with us and maybe give a few more details from which department he comes from, so that we will be able to help him out on the mandate stuff for the name change.
Definitely. So Mr. Prince, all you have to do is log on to vakilsearch.com, raise a ticket, and you will be addressed to within 48 hours. You'll be reached out from one of our colleagues. And with this, we would like to thank Ms. Pooja Shri for having taken time off. Yes, interestingly, we have one last question that has come in. One last question that has come in, and that that says, what are the procedures for property registration in India and what documents are required for the same?
Okay, so property registration procedure is such that the first thing that you need to do is you need to get all the documents executed. For example, if you're transferring the property to a sale deed or a settlement deed or anything of that sort, you will need to have the document executed and drafted. The next step would be you need to visit the sub-registrar office, that is the SRO office, and get an appointment from the SRO. And when, as per your scheduled time of the appointment, you would have to go to the SRO's office along with the witnesses and the persons involved. For example, if it is a sale deed and I'm selling the property to you, then it would be me, Sanjeev, as well as we need to take our witnesses, go to the SRO office, and in the presence of the SRO, we would have to sign the documents.
Right.
And we would also have to produce our ID proofs and all the other stuffs. So after the signing and all the due execution is done at the SRO's office, it takes about a week's time. So within a week, they would give us the duly registered and the executed documents.
Understood. I hope this would have made, this would have cleared certain doubts of Ms. Akila Sridhar. Interestingly, we have another query. This query comes from Instagram. Hello, Ashish Keys. If I have to use a trademark of an existing popular brand, but not for monetizing or profit making, then should I still get license from the brand?
Yeah, so very interesting question, Ashish, because I just spoke about this like sometime back, saying that if it is for commercial use, you will need to get the authorization. But that again does not give you, so trademark gives you exclusive rights. So the trademark owner has the exclusive rights to use a trademark. So even though you're using it maybe for a non-commercial purpose, or maybe Ashish is a student and he's using it for his maybe a research or something, but Ashish, you would still have to maybe not get a due license, like where you would have to pay for it, because generally if you need to use a trademark for commercial purpose, you would have certain monetary things involved, wherein you would have to pay the owner a certain amount of money for getting it. In this case, since it is a non-commercial use, for example, students or even NGOs using certain brands, in that case, although you do not you would not have to pay them any monetary instance, but you would still have to get their authorization. So the answer is yes, you would need to get an authorization, maybe not a legally notified license for using the trademark, but an authorization is needed.
Right. So Ashish, there you go. You have legal support just a click away. Do log on to www.wakilsearch.com for more interesting insights, and you can probably schedule a call back from one of our experts, and they'll be happy to address you. So with this, I would like to thank Pooja Shri for having taken time off and enlightened us with insightful answers to questions. So for more interesting updates, please do subscribe to Ask a Lawyer. Please do follow the hashtag Ask a Lawyer. Stay tuned. We'll be right back next month with another edition with another legal expert, hopefully addressing more questions and for an extended duration of time. Thank you.
Thank you.